I welcome especially Catherine to our
Hello,
session.
Catherine.
We want to discuss in the next, this break session, whether patents have a role or can be useful as a bridge between openness and commercialization. As we have learned, it is not as black as white as openness versus commercialization. So we put in a question mark. Is it really a contradiction? Of course, approach of open science is to promote the ideas and methods and share the know-how so that everybody can learn from it, use it, and is encouraged in his research. And open science also, to my opinion, is aiming at cooperation. And cooperation is a great value. But if you want to make profit with your ideas, then it's actually controversial. Then you don't want to promote the ideas, you want to protect them. You protect them from being copied by others. Your aim is not to disclose your know-how. Your know-how should be kept as a secret so that you can gain the most profit out of it. Others are not cooperation partners, but are considered as competitors. And the aim from the business side, to my point of view, is to hinder others. So is this really a question mark or rather an exclamation mark? We think with a patent system, both is possible. It allows to unify the opposite sides, and so the question mark is not questionable in this case. Here we see what are the both sides of the patent system. Actually, they have both the features of open science and secrecy. Because if you apply for a patent for your invention, you make a deal with the society, you get a limited monopoly, limited in case of geographical criteria or in time. And what you get for it is that you get the monopoly, but you have to reveal your invention. You have to disclose it to the public. And that is really a detailed disclosure so that everybody can see what you have done. So at the first part of our session now, I want to go into details, how this protection works, how the patent system works. So what is a patent, actually? A patent is the legal title which grants the holder the exclusive right to prevent others. And it's not a right to do a thing or to produce a thing, but it's a right to prevent others from making, using, or offering for sale, selling, or importing a product that infringes his patent without his authorization. And it's only value in the countries in which the patent is granted, and it's only limited value for a limited time. It is possible to hold it 20 years, but you have not to keep it up for 20 years. If it's not no longer useful in terms of economic interests, you can drop it. You just don't pay your fees, and it's not longer value. But it's possible for 20 years. And the owner of a patent has a right to assign, sell, or license these rights. And this is very important because most of the inventors doesn't want to produce their idea or something, or the product that they invented, but they let others do it. With one exception, in a scientific surrounding, in a non-commercial purpose, you can use all the information that the patents disclose. So it's not forbidden to, even if it is a granted patent, you can take this information and do your research with it. So what are the requirements for patentability? Only technology solutions or products can be patented, like product, devices, system. Here's an example, an office chair, for example, or chemical processes, methods, uses, chemical substances as such, or pharmaceuticals. Everything that has is a solution with technical background can be patented. But there are three more restrictions. These technical solutions have to be new to the world. This is very important, and this is really difficult, especially in the scientific background. It has to be inventive. It's the second point. This is rather a subjective criteria, and it's part of the discussion of the patent examiner and the patent attorney. If it's really an inventive step, the definition is it shall not be obvious to a person skilled in the art in view of the state of the art. So this has to be discussed. And the third point, which is, I think it's only there because it's nicer to have third points and not two, is there has to be an industrial application. But I think this is very often the case. You can sell a lot of things nowadays. Okay, here are some examples from the other side, things that can't be patented. For example, rules of games. This is copyright, but it's not patentable. The same is for business methods, mere ideas, or software as such. There are all points that can't be patented. There are other IP rights. Maybe you can apply or register a trademark or something like that, or you have an automatic copyright on it, but you can't patent them. Because it's for scientific purposes, it's difficult that the invention must be new. We have really want to go into detail at this point. So before applying for a patent, you should not publish it or write an article or press release, but you also should not write an abstract to a conference, for example. Research data, open research data, or write a poster, proceedings, or blog entry. And even the spoken word can be difficult. So if you're giving a lecture for your students or with your colleagues, maybe you have once a week a seminar where you present each other's work. You should be careful that all the people who are joining this lecture have signed a non-disclosure agreement. Normally, it is automatically done if you have a contract with the university, but students don't. So it's important that they sign a non-disclosure agreement. And of course, you should not sell a product before filing a patent. So here's a slide on how the process normally works. Normally, you apply for a patent in your home country. For example, in Germany, or at the national, you take the national route, or in another country. And then you can decide if you want to patent it in another country, for example, Italy or Spain or somewhere. But if you have in mind that you want to have more European countries, maybe where the patent shall be valid in, then it is more convenient to go the European route, the regional route, and you apply for a patent for the European Patent Office. So you have only one procedure, and afterwards, it is examined with the European Patent Office, and afterwards, the applicant selects the desired countries. Unfortunately, it's not the unitary patent which everybody wants, but it's at least an easier process. And in the end, you have a bundle of national patents and you go then to validate it in the countries. the third way would be the international route with the Patent Cooperation Treaty. This is for the whole world. It's a single application and can be valid in up to 148 countries, although no patent is valid in such an amount, such a high number of countries, because it's very, very expensive. But if you go through this Patent Cooperation Treaty, you have 30 or 1 month time before you decide in which country you want to apply for the patent or validate it. Yes. Okay, here is the procedure at the European office in detail. This point here at the beginning, when you file the application, is a very important point, because this is the time we call priority. And everything that comes after this day, it's not new anymore. So this application become part of the state of the art. Then this application is kept secret for 18 months and gives the applicant time to decide in what other countries he'd like to validate the patent and to develop business plans and such things. In the meantime, he gets a search report from the patent office. And after 18 months, it becomes open science. It is published, and it's available all over the world. Everybody can read it, and everybody can see how this invention or this technical solution is done. To get a granted patent, it has to be examined by the patent examiner, and if it was new and it's a good patent, it is granted. And after that, it is validation at the national offices. And the time it is granted, from that time on, you have 9 months where you can oppose against this patent, which is quite important too, because it's the only time where you can oppose a patent without going into court. And this process takes a lot of time, as you can see here. Approximately, it takes 4 to 5 years from application to the granted patent. And during this 4 to 5 years, it is not valid in front of court or something. So in this 4 to 5 years, the protection is not as strong as it can be when it is granted. Okay. At the university environment, you have to take under consideration that all the inventions that are made at the university belong to the university. And that is because it's a law in Germany, it came into force in 2002. It's the Employee Invention Act. And so all inventions are made at the university belongs to it. But you have to be careful. This is only valid if the employee, the scientist, has a contract. If it is a PhD student, maybe, who is living on a grant, then it's different. Then the invention belongs to the inventor. And if you have somebody like this in your team, you may have to make sure that you have a special contract with him, that his invention is transferred, and this contract is called invention transfer intention. Yeah. And as I said before, it's at the university, because the university's interest is to publish or perish. It's always a danger that you have a publication prior to the application. And if you're dealing with companies, like universities or students are not used to it, it is recommended that you always, when you talk to companies, sign a non-disclosure agreement. But the best thing is to have a patent application before talking to the university, to the company. How does this process in the university works? So if you have an invention or a finding that is promising or has potential for commercialization, you have to notify it to the technology transfer office, and they do the evaluation. They examine it and they do the evaluations. At first, they decide whether it is a job-related or a free invention. Even a free invention, like if it has at first sight nothing to do with your job, you have to report it to the university because they have to decide whether it's actually free or whether it has something to do with your job. That could be this invention could be developed within your job or your task you're working with on, or because of the experience you've gained during your work as a PhD student or as a scientist. If they decided it is a job-related invention, they can claim the invention, and then they have the obligation to register it and to support the valorization. The transfer, the IP rights go to the university, but the inventor has the right to be mentioned, and he gets a certain amount of the outcome. So he doesn't have to take any risk, but he can get some money from it. If for some reason the university doesn't want to follow it, the invention, or to valorize the invention, they release it. Then it can be handled as a free invention. Sometimes it's a part of it. Sometimes the university registers the IP rights maybe in Europe and in the home country, in the national country, but they gives free the international other countries like USA or something like that. So the inventor can file his patent in these countries. So this was the protection part. It's a really rush. I really rushed through all the steps of it. Maybe you have questions.
Yeah, I do have a few. So are you all in the same group then?
Pardon?
Are you all in the same group other than me? Or did other people join?
Christine is my colleague, and we are both from RWTH University, PatLab Center. Sorry, I should have introduced myself better.
No problem.
Daniela is also our colleague, but she is from a different department.
Okay.
And Damla is from the CSER board, I think. And Adriana as well.
From Scientific Knowledge Services.
Yeah.
Right. No, it was really clear. Thank you. I did have a couple of questions, if that's
so maybe
okay.
we can we can you can ask them now before we go to the information part.
Okay. So you'd said that in German universities, the staff are obliged to report their inventions to the university, and do they comply with that? Or do you have to keep persuading them, encouraging them?
No, it's German law, actually.
It's law, right.
So they will be punished if they don't do this.
Okay. Yeah.
Yes. And this is the only way.
I wish it was in the UK.
Yeah.
And likewise, then you said the university would register the IP rights.
Yes.
So would it therefore file a patent application?
Yes, they have to.
They have to, even
if they take the claim, if they have 4 months time to react. If you report your invention, and then the university has 4 months time to react, and if they don't react in this 4 months period, then they have to register it and pay for it.
Okay, that is really interesting. Yes, we don't.
But you have a technology transfer section at your university too?
Yes. So I head up the IP and commercialization team. So we everything you've said is very much what we follow, and those were the only exceptions. We have to continually encourage our staff to disclose inventions, and there are a number of them that will just publish without informing us at all. And I think those proportions of staff that will tell the university, it varies across UK universities. But otherwise everything is very similar. Likewise, our staff, the university owns their IP. Actually at Strathclyde, where I'm from, postgraduate researchers also assign their IP to the university when they matriculate. They can opt out, but that does mean the majority will have assigned as well. But not undergraduates are still inventors as individuals.
Yeah, it's the same in Germany.
Yeah.
And it happens, although we do a lot of public relation and a lot of workshops and rising awareness, it still happens a lot that people publish papers and then you can forget the patent, and it's really a pity because it would have been a great innovation, and then it can't be protected any longer.
On that point, I wonder if I can put in a question. Thank you, Suzanne, for the presentation. And I feel Catherine's pain in a way. I'm on the other side of the fence. I'm the open science advocate. And I've been consistently frustrated with similar issues, as Catherine mentioned. As you say, people are rewarded for publishing papers, not patents. Therefore, papers in their mind comes first. But I believe one problem in that area has been this lack of clarity between the two IP community and the open science community. And so I'm glad this event takes place. But in your last slide, where you go from capturing the IP in a patent traditional way versus partial release or free invention, I wonder, is that the interface between openness or open science and the standard way IP was handled? And if that is the interface, I wonder if there is a space for a group like this of 9 people here to really clarify that interface, both in time and in tools, so that scientists know that publishing a paper is just one of their options, depending on what the output value is for academia versus commercialization, right? And I don't think they have the reaction to ask that question, and they definitely don't know where the interface between the two is. And we frequently see the two communities, the IP community telling their tools and point of view, and the open science advocates advocating their own disclosure stuff, but we rarely really touch and say, okay, if your output is this, then you should take this pathway and this combination of disclosure and protection. And if your output is something else, then this is the right combination. I think we need to construct a training or some kind of a decision support tree for the ignorant researcher who cares just about a Nature paper to see that they have many more options. And in time, it's important when you publish. right?
That's a very good point. And this is what we want to say with our this workshop or seminar or speech. If you patent, if after application you are free, you can this is open then.
Yes.
And it's protected too. It's both.
Mm-hmm.
But maybe my colleague will continue now with the second part, with the information part. So this is maybe you can see that the IP world is open as well.
Yes.
Or gives a lot of opportunities to get information.
I think it's also important to talk about, rather than keep the discussion binary, patent or publication, is to really educate researchers of all the intermediate tools they have. If their knowledge is not patentable, what intangible outputs? How do we protect that rather than just dogmatically release them without even exploring capturing their value, right? So it's interesting to really get into the gray area between the patents. I think most people get it. If I publish a paper before that, then patent negated. But what happens in between? And I think that's where we as a community need to really focus with actionable advice.
Okay, Christine, will you share your?
Okay. Yes. Yes. Change.
So you have 10 minutes left.
Oh, we have 10 minutes left. Okay. Good. Then I'd start with the information function of the patent system. Suzanne outlined. One moment. Oh, it doesn't work. Okay. Suzanne outlined the protective function of the patent system, but I just want to concentrate now on the information function. Patents fulfill an important informative function due to the commitment of complete disclosure. And how does it work? Here we have some facts on patent information. And in comparison to the huge but really unknown number of scientific papers, patent information is a comprehensive but defined stock of around about 120 million documents. Due to the commitment of complete disclosure of R&D results, it is free of copyright and accessible for everybody. Patent information is language independent retrievable due to patent classifications. And it's really a unique information source, comprising technical information, comprising detailed bibliographic information on the players like applicants and inventors, on filing dates, priority dates, and countries of validation, on defined technological classes, and also on citations. And really important, I just want to outline here the citations. They just give you some insight on the uptake of the documents, on the activities of the scientific community, how they will reflect your work. And last but not least, patent information contains legal information, whether a patent is valid or not, or whether a patent is in force or not. Okay, patent documents have a standardized structure, and let's have a look at the structure of the documents. Here we have the first site. What happened here? Okay. Here we have the first page of a patent document. What is written there? We just see formal data like the date of publication, like designated states from the patent procedure. We have names of the applicant, application numbers, and a name of the inventor. But also we have on the first page subject-related details like the title, the abstract, and the technical class. The technical classes will be discussed below. A deeper look into the patent document reveals a very detailed description, the claims, denoting the technological scope of the patent, and more drawings illustrating the claims and the description. Okay, deeper to the content of patent documents, there are 5 important items. We have bibliographic information with these formal things like denoting inventors and dates and so on. But subject-specific data, we have 2 with the technology classes. Then we have an abstract, very concise abstract as search aid for the patent applications. And the most important part is the description. It is very detailed. It summarizes prior art. That means it summarizes the technologies known to exist. It names the problem that the invention is supposed to solve. And it offers an explanation and at least one way of carrying out the invention. The claims define the technical scope of patent protection, and the drawings are inserted for illustrating claims and description. Okay, now to the search. There is no search and patent literature is something different, like searching scientific papers. Because due to the economic and legal relevance, patents are drafted in a very specific manner using paraphrased items. For instance, a nail would be expressed as fastening means. That means if you search patents with the terminology, with your discipline-specific terminology you're used to, your hits could be very heterogeneous, and it could be that you won't find using your vocabulary the right patterns. That's why one classification system has been developed, enabling language-independent document retrieval. This is this classifications system has been developed by the patent examiners, and if the patent application arrives at the office, the documents will be classified by the examiners there too. It is divided into 8 sections and has around about 140,000 subdivisions. As you see here, this is the first level. It is a combination of letters and numbers. Okay, and the basic classification is the International Patent Classification, and therefrom derived has been therefrom the Cooperative Patent Classification has been derived. It has stronger, it has a more detailed subdivision, but it's based on IPC, and also it contains an additional Y section for interdisciplinary themes, and that is what I just wanted to outline here. Okay, now the value of patent information. In our opinion, the free access on the copyright-free full text is very important. Patent information is available in patent databases provided by the patent organizations. It is really in-depth publication of R&D due to the very detailed description. And last but not least, granted patents are landmarks of technological development in terms of the granting criteria, novelty, and inventiveness. Our job are patent searches, and I just want now to mention the benefit of patent searches. They make sure that the idea is new and avoid duplicated developments. Novelty searches and prior art searches ensure your funding and R&D strategy by by making sure novelty. Patent searches protect against infringement and litigations also by prior art and monitoring. And they deliver added value information on the players, on technological developments, on upcoming categories and so on. And the corresponding patent search is patent statistics. And for science, applications for funding programs in the framework of Horizon 2020 require prior art searches. That's why our message is patent search is mandatory at the start of all R&D activities. What are the tools for the search? There are two kinds of tools to exist. On the one hand, we have free access databases provided by the patent organization. Perhaps you know Patents Go, provided by the WIPO, or as Parsnet by the European Patent Office. And there are corresponding free access databases for the trademarks and designs too. And on the other hand, there are licensed databases. I just wrote here some databases we use in our everyday life at our patent library. What about the licensed databases? They are more suitable for elaborate search on complex topics, and they enable detailed analysis. They are more comfortable in working due to their refining options. That's why we just recommend, if you have a patent library nearby, then visit it and use the tools over there. Okay, now in terms of openness, I just want to focus a little bit on Parsnet, the free access database of the European Patent Office. It's a huge database covering around about 120 million patent documents. And here we just wrote the access. And I just want to outline the added value of a simple document number search. In searching, what are the informations from a document number?
1 minute left.
1 minute left, okay. Document number, 1 minute left, 1 minute left. Dann gehen wir hier, okay. Patent statistics, I think this is very relevant. You can analyze by the free search tools the geographic scope. You can analyze the technical classes, and you could identify inventors too, very active inventors. And now I just want to say some words on the patent libraries. There are different patent libraries in Germany, and there is a European network too. And their job is to support you in the different stages of the innovation circle, from idea evaluation by novelty search via IP protection, formulating an elaborated IPR strategy. And here they just want to ensure your market and maturation and enforcement by monitoring searches, and for further product development. you should always do statistical analysis and prior art for closing the circle. And the job and the services of PatLab centers is supporting you within the circle. It would be very interesting if you write, if you know the patent, if you know patent libraries, and what about your opinion on patent information building some interface to commercialization. Okay, thank you. 1 minute left. Did I get it?
So maybe Susanne, you will go to the studio already. Yeah, and I think you can say thank you, and we all return to the main stage.
Okay, bye-bye.
Thank you.